Donald Trump and his defense team have now responded to the government's request to postpone the Florida prosecution trial. It was scheduled for August, like right around the corner. And we know that this is going to be a complicated case. It's a historical prosecution. We've got classified documents. They're going to be fighting over every single document, whether it's a presidential record or a personal record, whether that was privileged in some way, shape, or form, and it's going to go on and on and on. So the prosecutors have already asked for a continuance. They wanted to postpone it to December 11th. I want to refresh our recollection on what their request was before we go over to Trump's continuance, because people are speculating that this is really part of the main strategy. And as this election heats up, one of Donald Trump's defenses or one of Donald Trump's strategies might be to postpone this until after the election so that it is not of consequence to him in the election, so that he can win the presidency and then pardon himself because he'll control the Justice Department and he can just make this whole thing go away. Sounds like a pretty good defense strategy. Now, most criminal defendants in the United States don't have that benefit of just being, well, I'm just going to wait until I'm the president. But Trump does. Now, the government, by contrast, wants to do the exact opposite. They want him convicted like now. And they know that every day that goes by is going to be another justification for Trump to say, hey, my election is right around the corner. And remember, the DOJ, they have their own rules and regulations about my election. Remember, we've seen other leaks that they will not prosecute people within a certain period of time because of my election. So the sweet spot is like now, which means I think that we're going to see the January 6th prosecutions come through very soon. But Trump, by contrast, wants to postpone. The government wants to go now. This is what the government said. Before we read Trump's response, this is what the government said. The government's motion for continuance says, we received and we reviewed your schedule, Your Honor, but we've got some additional things. We've tried to resolve this, but defense lawyers from Trump, they said that they do not oppose a continuance, an adjournment, right? They're going to delete this current trial date and then postpone it to another date. Trump's lawyers are great with that. They just want it, way after the election. So they're saying we're requesting a status hearing to address this. We anticipate that Trump's lawyers are going to file an opposition. All right. So we know what the procedural history is. They tell us that a lot of this stuff is going to take time. Clearances are going to enable counsel to review the classified discovery and the associated legal process that is brought forward under the Classified Procedures Act will inject additional time. So the government is saying, look, even we recognize that we're going to kind of need an extension on this thing. The government filed a motion for a pretrial conference, which this is what we talked about in a previous show, and that was ultimately granted. Walt Nauta got the continuance, and they'll be meeting on July 18th if the date serves. And so this is what Jack Smith was asking for before Trump responds. They said, well, we'll just post this to December 11th. That's when we'll start jury selection. We'll have a calendar call the week before on the 5th. We'll have all pretrial motions deadlines by the end of July, which is right around the corner, and that any delay is excluded from the speedy trial calculations. And speedy trial, the analogy that we often use was like the chessboard. You've sort of seen, whether you play chess or not, you've seen people with the clocks. If your side is going, the clock is ticking against you. If the other side is going, the clock is ticking against them. And so both sides get a certain amount of time. And if the government asks for a continuance that is not justified, well, that time for that 30 days or 6 months or whatever they're asking for, that counts against their clock, not the defense. If they both agree to it, then we'll say, okay, well, the defense wants that too. It's going to serve the defense, so we'll waive that time. And we'll say, sure, we won't include that bucket, that calculation. We'll not include the time that we are requesting. But if the government is requesting it and the defense objects to that and the judge sides with the government, then the defense is going to make the argument that that time should be excluded from them. They don't just get unlimited time. So that's what Jack Smith said. This was filed by David Harbach, Assistant Special Counsel. And Donald Trump and his team now respond to the government's request for a continuance. And this will shed light on their strategy about timing. This filing is 12 pages out of Southern District of Florida. Trump's lawyers now responding to the government's motion for a continuance. They say, the defendants here, Donald Trump and Walt, in the above case, request that this court deny the government's proposed order, the one that we just read through, and postpone initial consideration of any trial date until after substantive motions have been presented and adjudicated. So, it sort of sounds like they're asking for an indefinite trial date. I don't think that's going to happen, but what they're doing is laying the foundation for a continuance again, okay? They don't want to box themselves in at this point with a trial date. The government came out and said, okay, December 11th, that's great for us. Trump is not going to come back out and say, well, all right, how about July 14th? Or how about December 2024 after the elections? They're not going to do that, I expect, and I haven't read through this motion yet. I could eat my words here in a minute. But I think it's going to be indefinite because that will not box them in. They're going to ask the judge to set it in, and then when the judge sets it, they're going to come up with a bunch of additional reasons as to why that date doesn't work for them. They say, this extraordinary case presents a serious challenge to both the fact and perception of our American democracy. The court now presides over a prosecution advanced by the administration of a sitting president against his chief political rival, himself a leading candidate for the presidency of the United States. Therefore, Your Honor, a measured consideration and timeline that allows for a careful and complete review of the procedures that even led to this indictment and the unprecedented legal issues presented herein best serves the interest of Trump and of the public. And therefore, pursuant to the law, and based on the extraordinary nature of this prosecution, there is most assuredly no reason at all for an expedited trial, and the ends of justice are in fact best served by continuance. They say additionally, the legal questions here are significant, and they present issues of first impression. The intersection between the Presidential Records Act and the various criminal statutes at issue has never been addressed by any court. And this is a point we've made here many times. They say that in Trump's view, this will result in a dismissal of the indictment, as it should. The authority of the special counsel to maintain this action presents a potentially dispositive issue of first impression in this court. Additional significant matters include the classification status of the documents and their purported impact on national security interests. A lot of analysis, a lot of experts going to have to be brought in to take a look. And the propriety of utilizing any secret evidence in a case of this nature and the potential inability to select an impartial jury during a national presidential election. Man, the election is going to complicate all this big time. They say, moreover, the extensive and voluminous discovery, coupled with the challenges presented by what they say are the purportedly classified material, which I love that. Purportedly classified material. The only word that it would have been a little bit more snarky would have been allegedly, which would have been turning it up to like a level 9 a little bit. They dialed it back down by the purportedly classified material that you haven't even produced yet. It's going to require significant time for review and assimilation. All these questions further warrant a continuance pursuant to the law. And so the government, Jack Smith, and his view that these unprecedented issues should be adjudicated on an expedited basis is simply untenable, and it ignores the magnitude of this case. And I would ask them, do they disagree with that? They do think this is kind of a run-of-the-mill. That's why they keep saying that stupid phrase, no one's above the law, even though Hunter Biden and Joe Biden are clearly above the law, as is Hillary Clinton and many other individuals at the FBI. But they keep saying it. No one's above the law. But that is their justification for just moving quickly. This case is one of the most historical cases of all time in the United States. It's the prosecution of a former president. It really is of a historic nature, and he's running for office again. So it is a massive magnitude, and I think people who deny it, I got to presume they're being intentionally thick or maliciously dishonest. So the court, Trump's defense says, should therefore, before establishing any trial date, just leave that out, allow time for the development of further clarity as to the full nature and scope of the motions, a better understanding of realistic discovery and a pretrial timeline, and completion of the security clearance process, such that Trump can be fully informed as to the involved evidence and thus be able to present more informed arguments are necessary. They say Trump also expects that various key legal issues will be fully dispositive, all right, meaning they're not expecting this case to go to a trial. They're saying this is going to resolve before we even get to a trial. That's why we don't need a trial. We'll file a motion to dismiss, and it's going to go away. We'll file a motion to preclude. We'll get that audio recording thrown out. Or we'll say the search warrant was bad, and therefore all of the evidence obtained as a result of an illegal search warrant must be dismissed. Okay, there's no evidence, there's no documents, there is no case. So they're saying we'll file something, and then that's going to negate the need for any trial. We're not even going to trial. So given the broad discretion this court has when evaluating speedy trial exclusions, like does the time count or not count? So here, if he's making this argument, he should be waiving time. He should be saying, yeah, we're not invoking our speedy trial right, so we're going to postpone it, we'll waive a bunch of time. So the court should adopt and implement an approach that postpones the establishment of any trial date. They just don't want it at all. Here's what we say in support of that. Your Honor, says that Trump and Walt were indicted on June 8th on a series of charges centering on the defendant's handling of documents with purported classified markings. On June 13th, they were presented before the judge, John Goodman. Same day, Trump was arraigned, entered a plea of not guilty at the time. Walt later got arraigned. After June 13th, the government initiated the security clearance process for both lawyers to both defendants, Trump and Walt. Defense counsel has been working through the arduous process to obtain the necessary security clearance, and we updated you in the court docket on that one. But even after the applications are completed, there's going to be a delay while we get approved. You know how the government works, Judge. So the government's investigation into the matters here has been ongoing for over a year, right? So why do they want to bring this trial in like 6 months? Shouldn't we get as much time to prepare our defense? They say during that time, the government collected many hundreds of thousands of documents, dozens of witnesses interviewed. Many witnesses were presented before 2 grand juries. And so Trump is going to require time to fully study that entire process. And it took them a year. It's going to take us at least a year to evaluate not only what the government will produce voluntarily, but also whatever Brady material and everything else must and should be produced. So yeah, it's going to take, man, I can imagine, a lot of work to do. So this thing better go to probably December 2024 at the earliest. They say the government anticipates producing discovery in stages due to the sheer volume of documents that they collected and because of the procedural mechanisms necessary to produce against unlawful production of the classified info. Trump, remember, can't even take the police report home with him to review, right? You get charged with a DUI, you meet with your lawyer, he'll give you a copy of your police report. He'll say, hey, take this home, read it through, give me your thoughts on it. Trump can't do that. Trump can't even look at the police report, write notes about the police report, and take those notes home with him. Judge said, sorry, those got to stay with your lawyer too. We don't trust you. You're just the former president. You're basically scum to us. So the government produced its first production of, quote, unclassified discovery in June. It was substantial. Look at this. This is what I'm saying. How can they possibly get through all of this in August or December? The government produced 428,000 records in excess of 833,000 pages of documents. Just shy of 1 million pages of documents, consisting of 122,000 emails with attachments, 300,000 documents gathered from over 90 separate custodians. And we've got to interview all of those people and investigate them and verify that what they gave to you is true and honest and accurate, and they're not conflicted off. And we got to read every one of those emails, including the attachments, by the way, and all of the documents slowly, because we're looking for a defense. So, man, this is going to take even more time. Yeah. And the initial production also included 57 terabytes of raw CCTV footage. So far, there is 9 months of CCTV footage, but the final number is not yet certain. So they're going to need just another 9 months just for the footage, man. You can see I'm being a little dramatic here, but the argument is this is going to take time. Oh, another box? Well, gosh, it's going to take another couple months here. In addition, there will be additional productions of discovery provided by the government, including some involving devices and search warrants. Trump's team says the government has not produced all interview-related material and memorialization of those, so that is a boatload of stuff. I mean, just all these recorded interviews of thousands, if not tens of thousands of hours of interviews. The government has not informed the defendants when it anticipates producing those things, what it involves, or even approximate when it will be in a position to fully comply. So in other words, this is great. I mean, this is a great motion, honestly. This is well done. And they're saying, Your Honor, you can't possibly set a trial date right now. Why? Because their discovery is still ongoing. I mean, they don't even have an end date in mind. So if you set a trial date for July 2024, let's say 1 year from now, which maybe that is, kind of a keyed off point, like, okay, 1 year. And then we've got August, September, October, November, the election. Maybe it's 4 months out from the election, right? Just theorizing here. If, Your Honor, you schedule it in July next year, we don't even know that they're going to be done with discovery yet. So how about this? Let's just leave the trial date off and you just continue to establish some settlement conferences or some additional SEPA pretrial conferences to make sure that the discovery processes are on track. The government's efforts are ongoing, and the defendant, Trump, has no insight as to when any of this is going to be complete, nor do any of the parties know when the discovery is going to be made available to Trump and Walt. There's an extraordinary volume of stuff here. But once we have had an opportunity to review everything, we're going to have our own requests, Judge. They're going to give us a police report. The police report's going to mention something, and we're going to say, oh, well, we're going to need that. You didn't give us that. You said there was a camera right there. We looked through our discovery. We have all of the other cameras, but not that camera. So we're going to go back and we're going to file a supplemental request. You said in this interview you talked to this guy. Well, who is he? All right, well, we need more of it, so go tell us who that guy is. So they'll respond and they'll say, Judge, we need supplemental discovery, including all Brady material. And that's going to take them more time, and so we're going to have a round and around we go. So the defense says, but it's not possible with reasonable diligence for Trump to begin to identify what we're going to ask for in our supplementals without first evaluating what we've got. We can only do that after we know what they've given us. So unlike most cases, all discovery here are sensitive and high profile, unlike other cases. And Trump is unable to utilize other third-party providers to come in and help, right? It's all got to be highly systematized. Thus, an adequate and diligent review of the existing production is going to take considerable time and effort. And given the volume of information that the government has produced and the time required to electronically process it, counsel for Trump only accessed the initial discovery, for example, email and documents, but not the CCTV footage, which is still being processed. I mean, like they gave it to us, but we can't actually watch it yet. We just watched it for the first time in June 28th. And so until at least some initial review is completed, we can't really give you a meaningful position as to the schedule, right? Like it's too early for us, Your Honor. If we just gave you a date, if we just said, well, you know, July 2024 or December 2024, it would be just shooting from the hip. So there's too much discovery. We are not in a reasonable position to give you a date. But we know that as a defense team, we must be provided with reasonable time to do the job for our client. We need effective preparation to prepare our pretrial motions and to prepare for trial. Trump's defense. They say, in addition, the government will at some point produce what they say is purportedly classified material. And the government acknowledges the discovery burdens on information subject to CIPA, which is the Classified Information Procedures Act. And it is very detailed. To that end, the government, in its letter to the defense counsel, said that classified material is going to be handled separately, which includes witness statements and other things. And so they note for the court, you know, these are demanding and critical, right? Especially in cases of a first impression before any court in the United States. CIPA in general is just a big pain in the butt, but this one is the first one ever like this involving the president. CIPA establishes processes for determining before trial what is relevant, what is admissible, what kind of classified information that can be disclosed. Other courts, including in this district, have recognized that it's reasonable to delay trial where discovery is complex and extensive, especially where it includes classified documents. Trump's team and their meaningful review and consideration of these classified documents cannot begin until we even get our security clearances. And then only after review and consideration of that material can we even engage in an informed dialogue with the court about these issues. So they say, in general, Trump and Walt believe that there should be no, quote, secret evidence, nor any facts concealed from the public view relative to the prosecution of a leading presidential candidate by his political opponent. And I think this is an absolute bold statement, and I think it's true. If Trump wants all of this exposed, part of it, right, they're going to say is classified, so they can't expose the national security stuff. But a lot of these motions and filings, a lot of it is being done under seal. They don't want us to see what they're doing. But Trump and Walt, they say, show it all. What are you going to see? A love letter between Trump and Kim Jong-un? Whatever? Let us see it. How can you tell us that these are classified national security documents that are the worst thing ever, and then prosecute a political opponent in this country and just rely us that we're supposed to trust you on that? Don't trust us. You can't see it. We'd like to see it to verify that you say that it is what it is. No, you don't understand. It's a national security problem. Okay, we'll just sit here and do nothing, I guess. No, that's not how this works. This is the justice system, and discovery is a part of the process. Our democracy demands no less than full transparency, but it is nonetheless premature to even engage in any of this, and the court should therefore postpone its consideration until we can fully be informed. They say, significant effort is going to be required to sort through these documents once we get them from the government. Now, based on the government's schedule, trial would begin in December. But from a practical matter, even the CIPA logistics alone make clear that this schedule is unrealistic. And by way of further example, they give us some. They say, Your Honor, it's also very important to understand that the government's assertion about the nature of this case is wrong. This case presents novel, complex, and unique legal issues, most of which are a matter of first impression in this entire country. This court will need to evaluate the intersection between the Presidential Records Act and various criminal statutes forming the basis of the indictment. and constitutional law issues about the opinion clause, hopefully. These will be questions of first impression for any court in the United States, and their resolution will impact the necessity, scope, and timing of any trial. Moreover, as also noted above, the defendants anticipate pursuing constitutional, yes, and statutory challenges relative to the authority of the special counsel to maintain this action. All right. And the defendants may also challenge the purported classification status of certain documents. However, any such challenge cannot possibly be evaluated and presented prior to review of the actual materials at issue. We can't even give you an idea of trial, Judge, until we get the material. Again, contrary to the government's assertions, this case falls squarely within the complex case statute, and there is ample time to be provided for debate, presentation, and adjudication of significant issues prior to a trial. Now, while the government appears, for some reason, to favor an expedited and therefore cursory approach to this case, it cannot point to any exigency or urgency requiring a rapid adjudication. Unless they want to come out and put in their filing that they just want to imprison Trump before the election. They would really like to be able to say during the election that Trump is a convicted criminal. Like, they would love that. So they would do the same thing. A convicted felon, Donald Trump, convicted felon, Donald Trump. That's their urgency. But that's not a real good legal urgency. That's a political urgency. There is no ongoing threat to national security interests. Trump doesn't have national security documents. There's not any concern about any criminal activity. It's all done. But by contrast, Trump submits that the court's paramount concern here must be that Trump receives a fair trial, which gives the defense and requires that they have time to prepare. Requiring Trump to adhere to the current schedule and the government schedule would be prejudicial to Trump. The government's request to begin trial with a case of this magnitude within 6 months of the indictment is unreasonable, telling, and it would result in a miscarriage of justice. Proceeding to trial would deny Trump reasonable time necessary for effective presentation and would result in a miscarriage of justice. Therefore, Your Honor, this is what the law says. You can see that's why it's quoting it here. The ends of justice are served by granting a continuance, and the ends of justice that are served by the granting, they outweigh the interest of the public and the defense in a speedy trial. That's kind of the test. It's a balancing test. The ends of justice outweigh the best interests of the public and the defense in a speedy trial. Well, I don't know that the public really wants a speedy trial or that Trump wants a speedy trial. And the ends of justice seem to be in alignment. So they're saying, Your Honor, you have legal authority to grant this decision. Don't give us a trial date. Just postpone it. They say President Trump also, by the way, is running for president, and he's currently the likely Republican Party nominee, in case anybody forgot. Joe Biden's prosecuting the #1 Republican at the time. This undertaking requires a tremendous amount of time and energy, and that effort is going to continue all the way up to the election on November 5th. Mr. Nada's job requires him to accompany Trump during most campaigns around the country, and this schedule makes trial preparation with both of them very challenging. The preparation requires significant planning and time, and so the current schedule is untenable. They say, furthermore, careful consideration will need to be given to the ability to seat an impartial jury under the circumstances, proceeding to trial during the pendency of a presidential election cycle, wherein opposing candidates are effectively, in parentheses, if not literally, directly adverse to one another in this action, will create extraordinary challenges in jury selection and limit the defendant's, Trump's, ability to secure a fair and impartial adjudication. These considerations are relevant to any continuance. They say even the Justice Department policy cautions against taking prosecutorial action for the purpose of affecting an election, unless it's Trump, or helping a candidate or party. That's laughable. That's a DOJ policy. Oh my gosh, what a joke. The caution against taking prosecutorial action for the purpose of affecting an election or helping a candidate or party. They didn't get the memo with Trump or Hunter, apparently. So here they say there is simply no question any trial of this action during a pending presidential election will impact the outcome and, importantly, Trump's ability to a fair trial. And finally, they say previously scheduled trials in other matters for both Trump and defense counsel make it nearly impossible to prepare for this trial. Absolutely love this. So when you have a conflict, it's good practice in criminal law to notify them of your conflicts. And so what they've done now is they've listed all of their conflicts, which looks like for the next year, which is just great because he's just stacking them all in here. So he's just putting them, no, I'm super busy. I mean, between now and December. So I don't know, whenever you want to schedule it, can't do it. So, for example, Trump and Blanche are preparing for a criminal trial in New York Supreme Court, the other case that we're following. Keese and Trump are preparing for trial in Supreme Court in October. Woodward has 3 trials. Navarro, he's representing, that's going on in D.C., September 23. Schulman and Samsel also going to trial October 2 and October 23. You guys are really making my life hard. And so because I'm in all these trials defending all of the victims of your prosecutions, we will let the court know the pendency of these other proceedings and their collective impact on the ability of the defense to prepare justifies granting a continuance. And so for the reasons set forth, a continuance is warranted. Why? This case is unusual. It's complex. This case involves novel questions of law and fact. Trial on the 11th would deny Trump and Walt the ability to effectively prepare, and it would result in a miscarriage of justice. An accelerated trial like Jack Smith wants would be contrary to the interest of our nation in maintaining the legitimacy of and the confidence in, what's left of it, of our justice system. So the ends of justice served by granting the continuance outweigh the interest and the public in a speedy trial. And so respectfully, Your Honor, they say a continuance is necessary and appropriate, serves the best interest of justice in this unprecedented and extraordinary action signed by Christopher Keese and Todd Blanche and Stanley Woodward and Sasha Dayton, all lawyers for Trump and Walt. And this was an excellent motion, very persuasive, and I think absolutely right. I mean, it is a case of first impression. This has never happened before. The amount of discovery is so voluminous that Trump's team deserves every bit as much time as they got to defend himself and investigate what they investigated. And it's going to take some time. The judge, I think, is going to agree with that. And we've got CNN reacting to a bunch of this. We've got Jake Tapper hosting a roundtable with a bunch of other people over there talking Trump prosecution. Let's see what they're talking about and see if we can make sense of their language.
Today is the deadline for former President Donald Trump and his aide Walt Nauta to suggest a trial date in that classified documents prosecution. The Justice Department has asked for the trial to begin in mid-December. Let's turn to some of the most informed voices on everything in Trump legal world. We have with us Caitlin Collins, CNN anchor of The Source, which premieres tonight at 9 p.m. Eastern, only on CNN. Former federal prosecutor Ellie Honig, and of course the New York Times
prosecutor
Maggie Haberman. So Caitlin, I mean, I don't even know who to start with because it's just
prosecutor Haberman, who has a lot of access to Trump, and then Caitlin.
Bounty of brilliant people, but I'll start with you. The deadline comes as we're hearing special counsel Jack Smith's investigation into efforts to overturn the 2020 election results could be coming to a close. What are you hearing about that timeline?
Yeah.
Trump's being prosecuted in Florida. This next case that they file is going to have all of the same issues as the Trump prosecution.
It's not totally clear to anyone, I think, especially the attorneys of the people who may very well get indicted in this investigation, when this is actually going to happen. But people are bracing for it. It's something that they're kind of every day trying to read the tea leaves to see what's going to happen. I think the reason they think it's going to happen in the near future, however you define that, is because there's been a lot of activity within his office. He has been bringing people in. The people who appear
Jack Smith has been bringing people in.
And they've been with very aggressive deadlines. They're not allowing people to delay and come in later or postpone. It's a very quick turnaround of when they want to hear from people. And so I think it's raising questions of what this is going to look like. And of course, what he's asking the people who are coming in about, which are key moments here with the fake electors, that crazy Oval Office meeting. Those are all the things that they believe it could be the end of the investigation.
So you and I go way back when it comes to that December 18th Oval Office investigation, because you and I talked, because right after you found out about it, you and I spoke on the phone, and you were really worried because there are these powerful people talking about unconstitutional things, martial law, seizing the voting machine. So we know that Special Counsel Jack Smith is now looking into the meeting. How might this play into the investigation?
In a couple of ways, Jake. I mean, I think one way is that they're looking at Trump's mindset, for one, the fact that that meeting took place a couple of hours before. And, the meeting ended without him signing any of these executive orders that were not
special
drafted.
Counsel
Right, for Sidney Powell become a special counsel or to seize voting machines. And
he said, heaven help us. Yeah, nothing was signed. Nothing ever got signed.
Use the government apparatus to do so. None of these orders were drafted by his White House.
He didn't write them either, or sign them.
It ended without him taking action on that, but it was a couple of hours before he first tweeted, come to this rally, people,
January 6th.
January 6th. We'll be wild.
We'll be wild.
So one is mindset. I think one is how he wanted to use the government and was thinking about using the government.
Okay, so just so we're clear, it's a thought crime now, all right? So Trump has a meeting right before he posts on January 6th. Come to the January 6th event. It's going to be wild. At the meeting, apparently the Oval Office meeting was all of these other insurrectionists. They're like, Trump, just give Sidney Powell special counsel status. She'll go seize all the voting machines. We'll take over this country. We'll get the helicopter. You'll take Clavicle Girl. We'll go seize the Capitol on January 6th. You know, all of that stuff. Trump tweets about it, and they're going to make the connection with these other proposals that never went anywhere. That was the first stepping stone. That was the first domino. That put the little seed in Trump's brain. And so he said, oh, yeah, we're going to plot to take over the country, baby. January 6th is going to be our day. And that's why he posted the tweet. So it's just the thought, right? It's that meeting translated into the tweet, which is the intentionality that you need for the criminal charge, which whatever that is going to be, probably seditious conspiracy, amongst other things. And that's going to be their evidence. It's hilarious, I mean, if it's not insane.
But we don't know exactly what might come of it. We do know from a number of people who have been interviewed, to Caitlin's point, a bunch of folks have been in. There has been a focus on the lawyers. There's been a focus on Sidney Powell in particular, who was in that meeting. And because there are so many tentacles of this January 6th investigation, this is not the documents case, which was a discrete fact set. This is very different, and it could play out in a number of ways.
And Emily, let's talk about that, because if Special Counsel Jack Smith does indict Donald Trump on this, in the January 6th investigation, how on earth do courts manage 3 different indictments? You have in the hush money case in New York, you have in the classified documents case, you also have the January 6th, and then also potentially
They have a chart.
Georgia election medley. I mean, how does a court system even begin to maneuver this?
We use this phrase unprecedented quite a bit. I've never heard or seen anybody who's been under 3 different indictments, if we get one more, never mind 4, from 4 different jurisdictions at the same time. This will be...
Yeah, that's exactly why they're doing it. So this talking point that comes out can continue to be used. Never seen it before. Historical. Never seen anybody with 4 different indictments, all right, in different jurisdictions. It's a giant excuse to hyperventilate and turn this into hyperbolic language that they always do. Every time there's a Trump update, we get this type of talk.
A mess.
Oh, right, because classified documents is in Florida, and January 6th would theoretically be in D.C.
Right, and then we would have we have the state charge here
Georgia,
in Manhattan. And what I think is going to happen, some of this could play to Donald Trump's advantage, because his best defense here, his best strategy is delay. We will not try 3 or 4 cases between now and the election. I think it's not even 100% certain that we will try one of them.
I agree.
And ultimately, you would think, can't these prosecutors get together and prioritize? Because I think we can all agree, anyone can agree, if you take the allegations as true, January 6th is the most important.
Right.
The documents are second. And Alvin Bragg's case is far, far behind, yet he's
not
the
even
only one
relevant.
who has a concrete trial date. He's really taking up the prime trial real estate now in March and April. They can coordinate, but there's no indication they have done that.
On the classified documents case, today the special
too.
counsel, Jack Smith, accused Trump aide Walt Nauta of trying to delay, specifically saying his lawyer wasn't prepared for this hearing scheduled for Friday because his lawyer is going to be in D.C. What do you make of this?
Delay is a strategy. Delay is the strategy here.
It's a good strategy.
Every step of the way, Donald Trump and Walt Nauta, 2 defendants, are going to drag their feet and delay and kick and scream. It's going to be like...
Is that normal, though?
Yes. We used to say it's like trying to put a toddler to bed, right? Delay, 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 drag it out. But it's a strategy here. And this is just a proceeding to discuss how the proceeding is going to go. And yet, even so, Walt Nauta is saying, well, one of my lawyers is out of town. Let's push it off. DOJ's right to push back, and I think the judge is going to reject the effort to postpone here.
And
all right, the judge didn't. The judge postponed it to next week on Tuesday.
And the deadline the Trump legal team is facing today to tell the court their preferred timeline for this trial date. What do you think Trump's strategy would be when it comes to selecting the date? Because he can't obviously just delay it forever. That's not an option.
He would like for it to be after the 2024 election and in between that period between then and inauguration. I mean, they in their minds think this is not going to happen before the 2024 election. Now, whether or not Judge Cannon goes along with that, that is the wild card here to see what that looks like. Obviously, Jack Smith has proposed this date of a December trial date. They don't think it's going to happen then, but they will try to push it. But, I mean, we just found out the Iowa caucuses are going to be on January 15th.
Right.
Oh, see that? So Iowa caucuses are now coming up. So the election is going to start, like, soon. And then even if the judge postpones this thing, let's say she bumps it out 6 months from now. All right, that's in January. Iowa is voting in January? Good Lord. Are you kidding? Yeah, we're going to be in election season. So how are they going to go to trial?
All of those, prime trial real estate was a great phrase, but it's all of those competing factors, but they are going to try to push it as far as they can.
So, Maggie, obviously Trump's out there saying that every time he gets indicted, his poll numbers go up, and there is some validity to that. But in December...
He didn't like that admission. Yeah, there is some validity to that one.
If there is this classified documents case begins there, and let's just remember, this is a case that he's been bashed by his former defense secretary, his former attorney general, his former chief of staff, John Kelly, and on and on and on.
Yeah.
Do you think that taking place 1 month before the Iowa caucuses could actually maybe hurt him?
That's the big X factor to me, Jake. We have not seen a dynamic where he is having to face evidence being presented every day, witnesses testifying every day.
Present
It
them.
will also depend on how much it's breaking through and how much voters care and what else is happening in the world.
First of all, present them, okay? We'd all love to hear it. We'd love for you to unseal everything. Unseal it all if the case is so strong. First of all, we'd love to have the trials publicized. Can we have a special exception for federal courts so you can broadcast this whole thing to America? No, they're obviously not going to do that. And is the public going to care about any of it? Do you remember the January 6th Select Committee hearings? No, the public doesn't care, at least about their narrative of it. They were some of the most boring, bland things we ever saw. It was all just this big, bizarre show. There was like a big patty cake game where they all came in, gave their book reports, and cried in front of the cameras. No adversarial proceedings, no actual Republicans on there asking any interesting questions, no real new evidence of any kind. So if they do that again, this time it will actually be interesting because there will actually be a defense. Because Trump's defense team with Christopher Kesey and the other lawyers who just put together that very nice motion, they'll be able to present their narrative and their argument, and they don't want anybody to see that side.
But I do think it's an unknown. It's certainly something the other candidates who are competing against him in the Republican primary and in the Iowa caucuses are hoping will happen. They are hoping that this trial takes place before the caucuses. That is in some ways their best bet, because otherwise, I guess you have to explain to me what's going to stop him. We don't know what's going to happen. Predictions are not of much value, as we know. But so far, it's 2 indictments, and it has done nothing to shake his voters. So we will see if an actual trial is the thing that does that.
No, if this all does get pushed until after the 2024 election, the more serious cases, not Alvin Bragg, and Donald Trump wins, can he just dismiss the special count? I mean, like, what happens legally?
If this gets pushed beyond the election and he wins, they're all dead on the vine. All 4 of them, let's say, hypothetically. First of all, the federal cases, Donald Trump can either order his DOJ, dismiss those, or he can pardon himself. We don't know if that's constitutional, but the only way to challenge it is DOJ would have to indict him, and then they litigate it, but it will be his DOJ at that point.
Yeah.
The 2 state cases, we don't have any sort of case
all
law.
All dead on the vine.
I will just tell you, there is no possible chance that state-level prosecutors will be permitted to try a sitting president. So this is all or nothing for him if he can.
That's right.
All right, Ellie Honig.
That's right. I agree with that. I agree with that statement. I think it is all or nothing. I think Trump is playing that game. He is going to use offense as the defense. He's going to win the presidency and then just take care of all of this legal stuff on the back end.